piece by piece and shot them all down. Now, here in Massachusetts, we have specific case law that actually goes through the whole process of denying us our rights, because the courts in Massachusetts have actually continued to say that the Second Amendment was not an individual civil right. And I want to go through some of these cases because some of the people in Massachusetts, the Attorney General, the Mayor of Boston, the Governor, continue to say, well, the courts have ruled that our gun laws are constitutional, so there shouldn't be any changes. The problem is they've ruled it constitutional because they ruled that the Second Amendment wasn't a constitutional right. So let's take a look at some of the cases. Back in 1976, Commonwealth v. Davis, where more or less this all started in Massachusetts, it referred to the amendment is to be read as an assurance that the national government shall not reduce the militias. It also said the chances appear remote that this amendment will ultimately be read to control the states, for unlike some other provisions of the Bill of Rights, this is not directed guaranteeing the rights of individuals. This is the court basing their decision on the fact that we don't have this right, and we would probably never have this right. Again, another case of the Chief of Police of Shelburne versus Moyer in 1983, the burden is upon the applicant. This was the famous case in Massachusetts because they decided we did not have the Second Amendment as a civil right, that it was up to us to prove to the government we were suitable. It also said that the hearsay rule should not apply, and that the chief could use any means to deny us our right that they felt necessary. Ruggiero versus the Commissioner of Boston, again in 1984. No issue exists as to whether the Commissioner acted unreasonably in refusing to issue the plaintiff an unrestricted license. The plaintiff was found to be a suitable person to have a license. There's a key part of this case. The person was found suitable. However, from all that appears in the court records, the only justification offered for the plaintiff for an unrestricted license was that he does not spend his entire life locked behind closed doors and so forth. So basically, the courts were actually saying because this is not a civil right, even though someone is found a suitable person, it doesn't mean they should have a license that's not restricted arbitrarily by their local chief. And certainly, one of the most recent cases we have here that says it very clearly was the Runyon decision, which was a storage case that went up before the Massachusetts Supreme Judicial Court in 2009 and was decided in March 2010. The language from this decision says it all. It really clearly points out what the opinions of the courts are in Massachusetts as in regards to our civil rights. The judge's conclusion that the Supreme Court's decision in Heller required a dismissal of the count charging violation of Chapter 140, Section 130L rests on two premises, and the court said both of which were in error. First, the decision assumes the protection of the Second Amendment applies to the states as a matter of substantive due process under the 14th Amendment to the United States. And they're saying that wasn't the case here in Massachusetts just a few months ago. They also said, based on current federal law, however, we cannot say that the Second Amendment applies to the states, either through the 14th Amendment's guarantee of the substantive due process or otherwise. Really? Well, let's take a look once again at what McDonald just said Monday. We hold that the Second Amendment right is fully applicable to the states. We therefore hold that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. Those people who are out there and trying to tell the general public that this case changes nothing are basically whistling past the graveyard. This case will change everything in Massachusetts. It has to. You saw the language from the court cases that do not recognize the right. Now, things aren't going to happen fast here in Massachusetts. And where do we go from here? The Board of Directors of Gun Owners Action League will be meeting shortly to decide what the best course of action is. We still have about a month left in the legislature to try to make some changes for this year. If not this year, then hopefully next year. And we will also be looking at litigation cases, whether it's lawsuits against individual chiefs, but that's up to the Board of Directors, and they certainly will set an agenda for the upcoming years. But don't let anybody tell you that this doesn't change anything. because indeed it changes the entire premise of all the gun laws, regulations, and policies in Massachusetts that were all established and protected by the Massachusetts courts because they said we did not have a civil right under the Second Amendment incorporated through the 14th. We have that now, and we'll be working to change the laws here in Massachusetts and the overall impression of gun owners. So, we still have House 2259, the Civil Rights and Public Safety Act. Again, look back to the case that just came down. They separated this out. It's about civil rights and public safety. Sound familiar? Again, your organization was well ahead of the curve on that. We will continue to work with legislators to make sure that we start crafting gun laws that meet the civil rights standard and strict scrutiny of that standard here in the Bay State. Well, as we wrap up today, I'd like to wish everybody a happy and safe Independence Day. Make sure you spend time with your family this weekend. Make sure you remember the troops overseas that are protecting your rights here in the Commonwealth and also in the United States. And please support Gold in the future, because we need to make some substantial changes here in Massachusetts to our gun laws and the attitude of our own government. And that wraps it up for goldnews.org, video edition, July 2nd, 2010. We'll see you next week.